Your Honor, this is an application by the claimants.
Give me a second.
Oh, I'm so
Let the
sorry.
clerk
Okay.
to do her job.
Okay, thank you.
Good morning, Your Honor. Today we have an application hearing in the matter of CI 5001-2014 between Rafed, Abdel, of Khorafi and others against Bank Sarasin-Alpen Middle East Limited. Claimant is represented by Abdel and Counsel lawyers and legal consultants. Leading counsel Abdel, assisted by Muhairi. Defendant is represented by Al-Tamimi and Company. Leading counsel Zishandar, assisted by Robert Maxwell and Robert Karadersley.
Thank you for coming today. I have 3 questions. First of all, does Al-Tamimi going to represent their clients, or we proceed as an ex-parte application? Because I saw your email this morning that you are not going to represent the client and you're going to attend this hearing as an ex-parte.
Your Honor, we will always represent our client's best interests.
No, I mean this is in this application.
If I'm going to bring to your Honor's attention something that has transpired over the weekend and a commitment that our client is able to make, which may dispose of this application.
Your Honor.
Or
I will give you time. I ask him.
Thank you, sir. Thank you.
Or may allow your Honour, or may cause your Honour to decide not to treat this application as an urgent application and to adjourn it to another day. If your Honour is not with me on that, then our position today is that the application will proceed and should proceed, if at all, on an ex parte basis, although there is some dispute between the parties as to whether or not it would be ex parte or inter partes. I'm happy to address you on that in due course, but our position would be it proceeds on an ex parte basis. If that were the case, we are still here in our capacity to observe and to assist your Honour and the court should you require any further information. And if a point of information arises that requires further clarification and it is necessary to do so, then of course subject to your Honour's leave, we can assist in that capacity also. But just to make our position clear, if your Honour decides to proceed with this hearing, then we say it is on an ex parte basis, with all the consequences that flow from that, namely that there isn't, if you like, full participation or any formal participation by ourselves in these proceedings, and that there will be a return date which will enable the issues to be reconsidered and the validity or continuation of any order that you seek fit to issue today also to be reconsidered. May I just firstly give you...
Okay, you finished in this point, right?
Yes.
Okay, we'll consider it after we heard the claimant.
Right.
Okay.
What I was saying earlier on is that we can make a commitment now in open court which will make this application in our submission unnecessary, or will certainly mean that this application is not an urgent application. So you may want to hear that before you hear the full-on application from that.
I got your point,
yes,
and let's hear finish. My question to claimant: why you file a new claim while you have a running case on under 26/2009, and you have to file an application before Justice John Chadwick on that day?
We actually, Your Lordship, we...
Because now
had,
you create a new claim while there is a claim running before Justice John Chadwick.
We felt that it was necessary, Your Lord, because of the urgent nature, and that it could not wait until perhaps the next hearing before Sir John Chadwick. If I may explicate the background, we only became aware on the 5th of January that the first defendant in CFI 026 of 2009 had become deregulated by the DFSA. We were rather surprised by this information, since, if anything, in the first defendant's skeleton argument to support its appeal, before the Court of Appeals, I have a copy of it, sir, dated the 20th of November, the first defendant argued that Sir John Chadwick's decision should be overruled and reversed to protect its reputation. This is a company that's 10 years in existence, and without any notification to the claimants, to the Court of Appeals, which is still reviewing this allegation that the damage to the reputation of the company is such as to warrant a reversal of Sir John Chadwick's decision, and the first instance court had not been notified that the first defendant, the respondent in these proceedings, is no longer regulated by the DFSA. We wrote, of course, we don't want to run to proceedings immediately, Your Honor. We wrote the legal representatives of the respondent on the 11th of January. My letter is included and referenced in the witness statement by Jonathan Crook. We received a very non-responsive, extremely unsatisfactory response on the 11th. We had a hearing, Your Honor, last week before Sir John Chadwick. Sir Richard Hill, QC, mentioned this point of this discovery on the 5th of January to Sir John Chadwick at the very commencement of the proceeding. We had an adjournment of 1 hour in the proceeding, at which time Michael Brindle, QC, and Rita Jabala, a partner for Al-Tamimi, spoke with myself and Richard Hill and told us we would receive a letter the next day to our satisfaction, giving us details, because we were very concerned, sir, about a provision for contingent liability, which is also mandated by the DFSA. On the 13th, that was going to be the handing down of the opinion of Sir John Chadwick. We waited, we gave Ms. Jabala until 12 noon. At 12 noon, we received a call that she would need until 3:30. I asked her to kindly give us a response by 1, in the hope that if she did not, or the answer was unsatisfactory, we could submit our appeal to Sir John Chadwick. Unfortunately, the letter we did receive, dated 1 after 1 last week on the 13th, was completely unsatisfactory. If anything, it bolsters our position that urgent relief is required. We attempted to draw this to Judge Chadwick's attention at the end of the hearing for the handing over, but Sir John Chadwick had not had sufficient time to review the file, having received the file only 10 minutes before the hearing at 3:30. That is the reason why we scheduled this hearing, which is now taking place.
Okay, but why don't file as an interim application under 26/2009 rather than you file it as a new claim, as a Part 8?
Because we felt that that was the best way to seek urgent relief, Your Honor, to have this urgent matter addressed as quickly as possible. We felt that otherwise we would have to wait perhaps until the 28th of January for Sir John Chadwick to hear it, because of his potential availability on the 28th. If I can explain the substance of our concerns, you will understand why we felt the time is of the essence.
The appropriate decision will be to consolidate this claim with the ongoing claim 26/2009?
Yes, Your Lordship.
This is what you want to say?
Yes, thank you.
Okay. In regard the urgency, yes.
I was just going to make a point, albeit belatedly, but if the position is that the claimants are seeking interim relief by way of a claim, which is ordinarily the way in which a party seeks final relief, it seems to me that there is no proper application for interim relief before this court, given that it's been, if you like, put into a claim rather than an application. So the claim itself is for interim relief, which is not the proper format for bringing or for seeking interim relief from this court. You would ordinarily have to put it in an application in relation to proceedings that you intend to commence or proceedings that are already afoot. The only claim for relief that you see in the claim form currently before you is for interim relief, and therefore that claim, in my submission, is misconceived as a claim, and it is not an application by definition. So today with this application or adjourn it to another date so that all these matters, all these deficiencies can be remedied and the matter can proceed in the correct fashion.
I take my learned colleague's point.
Sorry,
I
I
think,
haven't finished.
Your Honour.
Your Honour asked me briefly about the question of urgency. But before I deal with that, may I make a commitment in open court that, as I said earlier, may dispose of the application entirely, and if not, it would enable you to take a view quite quickly as to whether or not this is an urgent application. And I'll do that now with your permission, if I may.
Your Lordship, may I at least have the benefit of just concluding what we view as being urgent in this particular matter. Then I will defer to my learned colleague.
Okay, let's put it in this way, otherwise we will fight until without any. See, I'm going to hear this application on two bases. First of all, I will hear it as an ex-parte application, which is I give this application as without notice for the claimant to proceed. Secondly, I will consider it as an urgent application. Then, after the claimant oral submission, will take a decision, and of course, if there is something, will be on retained date. We'll give you opportunity on that date as a respondent to this application. Clear?
Perhaps it's my fault, Your Honour. I'm slightly unclear about that.
This is my order today.
Yes.
For this application, I'm going to hear it on urgent basis. One. Second, I'm going to hear it as an ex-parte application, means without notice.
Yes.
And this application, I'm going to hear it without notice, as nothing before me, you are served properly, and there is no response from you.
Yes.
And there's no certificate of service as well, which is supposed within 3 days after the filing of an application.
Yes. Before you decide whether or not...
Already I decided.
I see.
Done. Now I'll give her opportunity for oral submission for this application, then go to decide for the application itself. Go ahead.
Your Lordship, I thank you. I will try to make this as quick as possible. Suffice it to say that the respondent is a very well-known financial services business. The respondent has been licensed by the DFSA for 10 years. In the first instance trial of this matter, Mr. Rohit Walia made repeated assertions that the respondent was a large and successful business. I have brought 2 transcripts where I can refer your Lordship's attention to certain statements that were made by the 5th day and the 7th day.
Jonathan?
Yes, I have them here, sir. These are transcripts of the hearing, the 5th day and the 7th day. I will refer to some testimony of Mr. Walia. Day 5, page 57.
Will be in which one?
It would be the one on the front saying day 5, May 2013.
Okay.
If you would look at page 57, lines 9 through 11, Mr. Walia states in his witness testimony, we have lots of large clients. This client of ours, Khorafi, is not the largest. We have much bigger clients than him. I would like to note that the Khorafis, the claimants, invested $200 million in total with Sarasin. I'd like to refer to the same day, sir, page 57, line 16.
Now,
again,
what are you going to prove?
Okay.
The risk of dissipation?
Yes. Sir, what...
Or are you going to prove there is an arguable case?
The dissipation of the client base.
Okay.
The client base is substantial. If you look, sir, at the second reference, he says we have a number of clients who we make a lot more money from than the Khorafis. We're talking here about a very well-known and substantial client base. On the 20th of November, as I mentioned before, sir, in their skeleton argument supporting their submission for a request for appeal, they have stated, and I have the reference here, that there is a need to reverse Sir John Chadwick's decision because of the damage to the reputation of the respondent. Yet on the 5th of January, without any notification, we understand that this is no longer a licensed entity carrying on business before the DFSC and the DIFC. We did receive a letter, and this is complete, full, and frank disclosure, from Al-Tamimi, dated the 13th of January of 2015. This was the promised letter. I have a copy. I do believe it was given to you, sir, as a part of our transcript. It states that the respondent has ceased to conduct any financial services or business generally in or from the DIFC. However, it will continue to maintain an office in the DIFC as a non-operating entity. We are instructed that the undertaking, by which we assume you mean the business of the first respondent, has not been transferred to another entity or entities. The next paragraph, they refer to the fact that the first defendant has committed to the DFSA that it shall not reduce its capital nor reserves, nor remit any dividends from its accumulated profit reserves, save for the purpose of covering the first respondent's routine expenses, such as rent, utility bills, and legal expenses until the conclusion of the claim 026. Your Honor, I note there is absolutely no reference in this purported undertaking to a provision for contingent liabilities. There are no details, sir. This is not an undertaking that protects the claimant's interests. As we speak, there could be the dissipation of the entire client portfolio, undervalued or for no value. We have no information on this. We do not want to burden the court with unnecessary proceedings, but with all due respect, Your Lord, this is not an adequate basis for the claimant to rely. The undertaking also that the DFSA is not something the claimant can itself enforce. We need a clear undertaking from the respondent in this case regarding the status of its assets. The quantum hearing, from our freezing order, which has some deficiencies in it, I do grant, but on our freezing order we were asking only for limited relief, only until March. The next quantum determination has now been established for the 2nd of March, Your Honor. We are simply asking for a freezing order, a stoppage of any activity.
And what happened to the $10 million?
The 10.4 plus 1 million is currently on the DIFC court account.
It's already paid.
It's already paid. But I would like to bring to your attention, sir, that we had tremendous difficulty enforcing the payment order for Sir John Chadwick. We were compelled to issue a winding up petition in order to get the respondent to make that payment. Without the winding up petition, which I personally served on the respondent, we would not, I venture to say, have that payment on the DIFC account. The defendants, first and second, have done everything they can to delay payment. They filed an appeal, a motion to stay the execution of Sir John Chadwick's order issued on the 30th of October. We had a hearing before Justice Giles. He dismissed the motion on the 20th of November. Payment was actually due, sir, on the 20th of November, yet no payment was made. I issued a payment request letter to Rita Jabala of Al-Tamimi on the 24th of November. I received not a response. We were literally forced on the 30th of November to serve a winding up petition on the respondent and the DFSA, and then we received the payment on the 2nd of December. I submit, Your Honor, that it is extremely difficult to get the respondent to comply even with court orders. The respondent has deployed a number of tactics.
Sir John Chadwick still didn't issue his judgment on the, which as you mentioned, will be on March.
The quantum determination on the remaining heads of loss will be starting the 2nd of March, possibly spilling over to the 3rd and the 4th of March. Then Sir John Chadwick must make his determination. It is at that time that we will know the extent of the losses and the damages, sir. But right now, we do indeed have the 11.4 safely in the DIFC court, which covers one head of loss, which Sir John Chadwick deemed had been already agreed between the parties. It only covers 1 million of the expenses, and the expenses on this litigation, sir, are well in excess of 10 million US dollars. They could not be verified at that time because of a dispute between the claimants and their prior counsel, KBH Kanun. I think you remember this. We are in the process of a client-owned solicitor assessment. We will have all of that information in January, February, so that in March there will be a clear understanding of what the damages are in this case, as well as the costs after the client-owned solicitor assessment, which is being carried out under the auspices of this court. Until then, we feel exposed, and we feel if we had been notified, if we knew about the deregulation, but within 6 weeks of the respondent's own statement that it needed to reverse Sir John Chadwick's decision based upon its reputation, we find out on our own that they have been deregulated. We have done everything we can. We are solicitous of a deregistered, deregulated. It means it is no longer regulated by the DFSA. It is not an operating trading company. It is not an active financial institution. It has been an active financial institution for 10 years, and then suddenly, after the decision of Sir John Chadwick in August, after the issuance of his order on the 30th of October, after the dismissal of their motion to stay execution of that order on the 20th of November from Justice Giles, suddenly we ascertain on the 5th of January that they are now no longer regulated by the DFSA. This is the reason, sir, for our concern, based upon the pattern of conduct by the first defendant. Perhaps I should also mention in closing that Justice Chadwick had also felt that there was an issue as to the integrity of management of Rohit Walia in the case, and I refer to Justice Chadwick's decision, his judgment dated the 21st of August. I feel that there is a very sufficient basis here for granting us this urgent relief, which we have stated is only until the quantum determination has been concluded by Sir John Chadwick. I feel that is an adequate protection. As far as fair and open disclosure of all things, I was of course going to bring to the court's attention the respondent's objection that this is all without proper notice. We have attempted over the last few days to reach an understanding as to a proportionate undertaking that would satisfy the claimants. We have not succeeded. We have not received anything that the claimants feel is sufficient upon which they can rely. We have no idea, sir, as to the existence of any provision for contingent liabilities which would cover the losses. I would like to add that pursuant to the order of Sir John Chadwick on the 30th of October, that costs were to be paid by the first defendant, the respondent in this application, to the extent of, and correct me if I'm wrong, learned colleague, 90% indemnity basis.
Before me, only one respondent,
The
right?
current respondent is the first, and the conduct of the first respondent was deemed by Sir John Chadwick to be so egregious that he found that the cost should be reimbursed to the claimants 90% on a full indemnity basis. Judge Chadwick is also considering and has not excluded the possibility of multiple damages due to the clear breach of the regulatory law. This client here, this respondent here, has egregiously breached the regulatory law of the DFSA. It has many adjacent companies, affiliated companies, and we are concerned, based upon Mr. Rowett's own testimony as to the voluminous client base, we are very concerned, sir, that assets, client portfolio, are being transferred to affiliated companies under value or for no value. We are only asking for relief until the quantum determination has been concluded. Not permanent, not forever, but only until that time, so that at least, if we hopefully do succeed, if the appeals are rejected, that there is at least something in this jurisdiction for the claimants to assert their damage award against. We are concerned, as a final point, that if we do not obtain this relief, and this company indeed has transferred its assets and its huge client base to affiliated companies, and there is nothing upon which the claimants can assert their damage claim against, that we will be forced to go against the second defendant to the extent that we can recover that. And they will certainly raise jurisdictional objections since the second defendant is in Switzerland. This is what I wanted to say. I have additional documentation here. I can show you the skeleton argument submitted by the respondent and the quotation. I have all of the correspondence here. I am not privy to show the without prejudice correspondence over the last few days. Yes, there have been discussions, but they have not been satisfactory, and as of this very minute, no undertaking has been offered to the claimants that is a satisfactory basis.
Let's come to your freezing order draft.
Yes, sir. We need to bring to your attention, there are some typos, okay? It was done, regrettably, in great haste on Wednesday morning because we waited until 1 o'clock for Ms. Jabala to contact us. I have done a markup, just correcting some minor typographical errors. I can share that with your clerk, if you wish.
Okay, let's go one by one.
Okay, here. This is the markup. It shows some typographical errors in this case.
Your Honour, if you would permit me at some stage.
Yeah, I will. Yeah, I will.
Great.
But you are here to assist the court.
Only to assist the court.
Yeah, okay. And in regard, consolidate this claim with the 26, 2009. How are you going to deal with this?
I will make an application that it be consolidated into 026. The only thing, sir, that I wanted to avoid is any time lost waiting for the next available hearing before Sir John Chadwick, which I understand may be as late as the 28th of January.
Now, the main case, which is 26, 2009,
yes,
will be full determined on March, right?
I expect that there will be an order by Sir John Chadwick
For the second quantum.
after the hearing. Now, the hearing is definitely scheduled, and lead counsel have all committed their availability. So all of the QCs are available on the 2nd, the 3rd, and the 4th, sir. So there is no way that it's not happening. It is going to happen, and there should be a determination shortly thereafter. But, Your Lordship, you know Sir John Chadwick better than anyone else. I don't know when he will finalize his order, but I can only imagine it would be in March.
Fine. Yes.
Your Lordship, Your Honour, excuse me, without preempting any decision that you make, just one issue to flag up. In the event that any order was granted, and we say that no order should be granted, ordinarily, as you're aware, the return hearing date for the inter partes hearing ought to be within at least 7 days, or not more than 7 days of today's hearing date, subject to court availability. And I hope that my learned friend wasn't suggesting that any return hearing date take place on or after the hearing that she has just mentioned, which she says all QCs have indicated that they're able to attend. So if you were thinking along the lines of granting an interim injunction at this stage, we would suggest that the return hearing date be next week. That would serve the interests of all parties and the administration of justice. I park that point to the side for a moment. It is important in my submission that the following factors are considered in this application by the court. The first is what of course, are the implications of deregistration. And what I would like to do is to bring your attention to a letter which is in the application notice, or the claim notice as it were, at page 170 of the bundle. So it's in the
Which bundle?
application notice bundle, which is the only bundle before you. That's
The bundle before me is without notice, but it came to your attention that by court email when they sent to adjourn from Thursday to today.
yes.
This is what before me, nothing
So
more than
you
that.
have no documents in front of you.
Nothing.
Well, that causes me some concern, because of course there is a duty to make.
So what is before me is an application, and Mr. Jonathan.
Yes, sir, he's referring to page 170 of Mr. Crook's witness statements.
I see. Thank you. I'll take it.
I'm sorry. I just wanted to clarify.
I misunderstood Your Honour. So you do have the application made by the claimants in front of you. It is page 170. That is a letter from
170.
page 170. If you just turn over the page, at page 171, you'll see that this is a letter written by Christian Cameron, the Associate Director of Supervision in the DFSA. So he is an individual who is senior and takes decisions relating to regulatory matters in the DFSA. And of course, if any commitments are made by a deregistering entity, then he is somebody who is fully aware of it and takes those matters into account. This letter is a letter that is in direct response to a letter sent by Mr. Crook, and you've seen his witness statement.
Yeah, I saw.
This is a response to Mr. Crook's letter expressing concerns about why the DFSA has allowed deregistration of the first defendant. And in that letter, Mr. Crook expresses concerns about the ability of the first defendant to meet any judgment order of this court if they were deregistered. And what this letter does is to respond head-on to Mr. Crook's concerns. Can I invite you to read this letter, and in particular, to look
Which
at
page?
page 170.
This is the same letter.
Yeah.
Yeah, okay. I saw that letter.
Yeah. And can I ask you just to look at the fourth paragraph to the right of the second hole punch? Your letter does not indicate in any way how the withdrawal of Bank Saracen Middle East's license negatively impacts the ability of your clients to obtain relief in relation to the judgment of DCJ Jadwick, dated the 21st of August. In any event, and despite the withdrawal of its license, Bank Saracen Middle East's legal personality remains in place. If you have any questions in this regard, you should contact the DIFC Registrar of Companies. That is an important statement from an individual who is aware and has been aware of proceedings from the very outset. He is also aware of the judgment order because in the letter from Irwin Mitchell by Mr. Crook, details of that order are set out very clearly and very explicitly. If the DFSA doesn't have concerns about deregistration per se, you may think that that is an important factor to take into account when considering what has been alleged regarding the dissipation of assets. But that's the first point I make. The second point I make is this. You were read an extract from a letter from Rita Jabala dated the 13th of January 2015. That letter, I'm not sure, is not in the bundle of documents before you. Can I give you a copy of that letter?
And 13th of January?
Yes.
With all due respect, this was given to the registrar, to Mr. Nasser, last week, to be included in the bundle.
Actually, I have 3 letters from Rita Jabala.
Yeah.
Or, and I said from Al-Tamimi.
Yes. This is a letter dated the 13th of January 2015.
Both of them.
I see. Well, the letter I'm referring to is a letter
Okay.
which, under the...
Referring to the claim 26 2009.
Yes.
Right.
It's the penultimate paragraph. It starts as part of its withdrawal application.
Yeah, this is the one.
Yes. You'll note that Bank Saracen Middle East committed to the DFSA that it won't reduce its capital. So, compliant with that, it won't reduce its reserves, and it won't pay out any dividends from accumulated profits or reserves. Now, Your Honour will know that Bank Saracen is an advisory business, deals with investments, commodities, foreign exchange. It deals with money. It has client accounts. Your Honour will know that having regard to the nature of its business and the nature of its assets, the commitment that was given to the DFSA in accordance with its regulations is one that is comprehensive and deals with all the concerns that the DFSA would have regarding a company that was deregistering to ensure that its customers' interests were protected. And of course, the claimants were a customer of the bank. The DFSA granted that deregistration subject to the commitment that was given. You might think that a bank in the DFSA providing that commitment to the DIFC, providing that commitment to the DFSA is, well, I'll let you form your own view about whether that is something that allays the concerns of the DFSA and also that of the claimants in this case. So I just wanted to bring that letter to your attention as well as the letter from the DFSA. And your Lordship,
In conclusion,
just briefly, Your Honour will be aware that, of course, the test is a serious risk of dissipation of assets. I say this as I've sat here today. We haven't had a shred, a scintilla of evidence indicating either that assets have been dissipated or that assets will be dissipated. What we have is evidence of a company that is ceasing to trade, that has deregistered. And my friend talks about contingent liabilities. Well, no judgment order regarding damages in this case has yet been issued. If it is issued, the claimants are creditors in line who will be entitled to seek payments for outstanding liabilities, just like other creditors. The fact that the company has ceased to operate and is deregistered does not affect that position at all.
Your
sorry,
Honour, I thought you were going to be brief.
My learned friend has relied heavily on the late payment of the $11.4 million by way of interim payment. What she has failed to do is to bring your attention to the fact that the reasons for the late payment are still disputed. And it's unfortunate that she failed to do so. And I would invite her to clarify that the reasons for the late payment remain disputed and to confirm that the reasons given, that she is aware, that her firm is aware, and that the claimants are aware of the reason provided by the respondents as to why there was late payment. But in any event, that payment has been made. And I say this for the benefit of my clients. The suggestion somehow that we have flaunted orders of the DFSA or orders of the court is frankly a nonsense. The fact that a party seeks to appeal and seeks a remedy incidental to appeal by way of the stay of a judgment order cannot and should not be regarded as any kind of breach of an order. That is the entitlement of a party. That is precisely what we did. And in the event that the appeal is successful, it would have made sense to apply for a stay, either of the judgment order or indeed of any interim payment awarded by the court. So I'd invite you not to put any stock in that. Those are my observations.
Okay.
Quite briefly, Your Honour.
After you finish, we'll adjourn for 15 minutes.
Of course.
And I will invite both parties, if you're going to reach amicably or an agreement in regard to this application. Otherwise, I'm going to issue my order after the adjournment of the 15 minutes. After the please.
I did indicate earlier that we're prepared to give a commitment in open court in the same terms in relation as are set out in the letter of the 13th of January. It isn't clear to me how it's suggested that client lists are an asset. I mean, they may become an asset, but how they are currently an asset, firstly, and secondly, how one dissipates that asset. But if all that is, if it is all that the claimants are concerned about, then I will try and take instructions at this stage in relation to that issue. But I'm still unclear as to how it is suggested that there be a dissipation of that asset.
Yeah, I got your point, and may I proceed? Then
Thank
we'll
you.
adjourn.
Thank you. I just very briefly, Your Honour. First, it has been vehemently stated by my learned colleague that we have been given provision of reasons for the late payment. Your Honour, I can assure you that my letter to Rita Jabalo, the partner of Al-Tamimi, regrettably she is not here today, well, on the 24th of November, requesting payment, which was actually due on the 20th, and kindly providing bank account details of the DIFC bank account, was never responded to. In fact, we received absolutely no response, and after we filed the winding up petition, we were notified by Lina Hatim of the Registrar's Office that payment would be effected, but would not be in the account until after the holidays. We dispute this. I am unaware of this. I would, of course, bring this to your attention. I would just like to briefly indicate that there is a requirement in the DFSA rulebook, the general module, and I will show it to Your Honour. It is point 11.4. Mr. Crook references it. He quotes from it, but I will show you the rules. 11.4 deals with the requirements in connection with the withdrawal of a license at an authorized firm's request. And 11.4.1 states at subparagraph D, an authorized firm seeking to have its license withdrawn must submit a request in writing stating that it has discharged or will discharge all obligations owed to its customers in respect of whom the authorized firm has carried on or will cease to carry on financial services in or from the DIFC. I'll just show this to you so you can verify this.
It's here, written in his written statement.
Okay, fine. It's just I've copied it. These are the actual rules. If you wish to look at it, I've put the indication where it is. This is axiomatic. It speaks for itself. I would call Your Honour's attention to the fact that nowhere in the correspondence to date submitted by Al-Tamimi is there any reference to provision for contingent liabilities. It's simply not mentioned. What we see is that their routine expenses, like their rent, the utility bills, and I would suggest Mr. Al-Tamimi's legal bills, will be paid for. But there is no reference to some provision. Now, we're not asking for anything beyond March. What we're simply asking for no dissipation immediately of further assets. It is regrettable. It's extremely interesting that my learned colleague does not think that the dissipation of client accounts is not an asset. The goodwill of a company and its client accounts is perhaps the major asset of a financial services company. And if one visits the location of Sarasin-Alpen, one will see many, many related companies. Those client accounts can be easily transferred under value or for no value inter-party or in between the companies. All we're trying to do in the overriding objective, in the interest of justice, is for a short period of time, after this astounding information which was never communicated by Al-Tamimi, that there has been a deregulation, that this is basically a shell company, that this is no longer an operating financial services company, that all of the clients that Mr. Walia was very proud about discussing in his witness testimony before this court, where are the clients? We want to ensure that there just is a stop right now while there is the quantum determination. We're not asking for anything more than that. And also, in the freezing order we had drafted, it is so limited to March. It is also limited that, assuming that this is still an operating company, that it may continue its operation in the ordinary course of business and for full value. But what we seek to avoid, Your Honor, is a dissipation of assets, including exceptionally valuable client accounts, for undervalue or for no consideration at all. That is basically it. I do not want to overstay my welcome.
We'll adjourn for half an hour. We'll
Thank
come 11:15. And if the parties willing to discuss in regard to this application to reach an agreement, I'm happy to hear that after adjournment. Then we'll issue my order in regard to this application. Thank you.
Thank you very much.
All right.